So hello everyone, and welcome to our lecture recording for chapter 4. And for this chapter we're gonna cover 4 learning objectives in relation to how law is made. And let's start then with the first objective, which asks us to identify the main sources of law and discuss methods in locating resources. Alright, so the chapter of course starts in your textbook on page 86, and the key point there is that there are 2 main sources of law in the Australian legal system. And the first one is what we refer to as case law, or judge-made law, which is made up of both common law and equity. And the other one is what we refer to as statute law. What we want to really get out of this chapter is the main principles. We're talking about legal principles, i.e. Legal theories underlying each one of these sources, which is essential for your ability to understand how the legal system actually works. So you will meet quite a number of expressions today, especially in Latin, and this terminology is basically what you would use when you study the legal system. So the first thing I want to emphasize in relation to these sources is that they need to be readily available. So we're talking about not just case law or statute law, but in addition to things like delegated legislation and international treaties. And you'll find more about these 2 sources in the in brief box again on page 86. In order for us to make sure that these sources are readily available, we, historically at least, provided law reports. So in particular in relation to judge-made or case or common law. So the approach, in order for us to allow for accessibility to these sources of law, is to enable people to find the case law or the statute law in certain forms of reports, either law reports in relation to judge-made law or from the government printers in relation to federal and state or territory statute law. That was really historically. Today, of course, with the 4th revolution, or the information revolution, and the advent of the internet, you are able to access most of these sources online or on the internet. And you are given a number of web resources, in particular the Commonwealth Government site comlaw.gov.au, which provides you access to current Commonwealth and territory statutes, regulations, government reports, Hansards, and current bills. Hansards basically is something that you can again check up in the Australian Law Dictionary. It's basically the reports of the proceedings of Parliament and of its committees. And then there is the Australian Legal Information Institute website. Both of these are given to you on page 87 of the textbook. And the key point is that both of these provide free access to Australian cases and legislation. The latter, which is the Australian Legal Information Institute, also provides a large index of New Zealand statutory and case materials, as well as an extensive library of other legal websites from around the world. Now, a word of caution here is that the OSTLE is a convenient starting point. So this Australian Legal Information Institute website is just a convenient starting point, but is not exhaustive and is not official. So for accuracy, you need to refer to the relevant state or territory or Commonwealth sites for the most current material. Okay. All right. Let's then move on to talk about finding cases. So again, the first source is case law, and the idea again is that we want to look at one more time how you can find these cases, and that is done through what's known as a citation. So every case comes with a case name and a case citation, and you'll find that on page 88 of your textbook. Now it starts by talking about traditional law reports. So you'll find that these law reports have something similar to a number referring to the year number from which the case judgment was reported, and it also has a number that refers to the page numbers, where you can find these reports, the case report, in a specific law report. One of the examples given to you on page 88 is the CLR, which is the Commonwealth Law Report Series. And one way we can actually look at that is in fact on the internet. So if you go to the Wikipedia case citation page, so you just type Wikipedia case report abbreviations, it gives you case citation Wikipedia, and you will have a comprehensive, almost comprehensive list of law reports, that is case law reports from Australia, but also from around the world. Okay, so when we go down to the Australian section, you'll find there is more about Australian legal citation, but it gives you, for example, Mabo, which is what we saw in previous chapters, one of the cases we saw in previous chapters, and it shows you how it is reported. It gives you the case name, the year of the decision between parentheses rather than brackets. The reason for that is that you are provided with a volume number. If there is no volume here, then you'll find that this year is given in brackets rather than parentheses. Okay, the report name, the abbreviation, and you'll find all abbreviations for the Australian series given here. And there's also talk about the neutral citation, which is also referred to in your textbook. And the neutral citation really has become more prevalent because of the internet. So once the decision is handed down in a given court, especially the High Court of Australia, you'll find that it is reported on the same day, and that's done online. And because there's no report yet, no law report of the case itself by the reporting sort of agencies, you'll find that this is reported first in a neutral citation. So on the website or on the internet, you can go and search for the case by knowing the year it was decided, and you'll find that always in brackets because there's no really volume number here, and you'll find the court identifier rather than the report identifier, and it's always a 3-letter abbreviation, or not always a 3-letter abbreviation, but sometimes you'll find that a 3-letter abbreviation similar to the law reports like the CLR. In our case here, the example given to you on this web page, you find that they refer to the High Court of Australia, and then there's an ordinal number at the end that refers to the sequence of this judgment in that year. So it was the first judgment, in our case here, it was the first judgment in the year 2005. And you can find much more about the abbreviations in other jurisdictions. And I think I'll leave it there for you to have a look at. Now, there's a mention here of something called the Australian Guide to Legal Citation. Okay, this is something you should be become familiar with, at least for your assignment purposes, although it's not essential. So you can use other legal other citation methods if you want, but this is really the preferred one because that will let you know how opinions or journal articles are written in Australia and what kind of citation system they use. Alright, let's leave that for the moment and we'll come back to it in a minute. For now, we just talked about the electronic reports and the traditional law reports, and that takes us to our second objective for today, which asks us to explain the doctrine of precedent and the rules of its operation in the court system. Alright, so let's then move on to page 90 of your textbook and talk a little bit about this idea of the doctrine of precedent. Now, the key point behind this doctrine is that the courts or the court system, especially the superior courts, can create law. This was especially important before the sort of proliferation of statute law and really the supremacy of Parliament in relation to the creation of law. So under the common law system, a court is bound to follow decisions of courts higher than it in the same hierarchy of courts. What does that mean? For example, if this is a federal court, say the Federal Court of Australia, and it wants to decide something that has been decided or something similar has been decided on by the High Court of Australia, which is higher in the hierarchy of the federal court system, then that federal court is bound by the decision of the HCA. And for the operation of this doctrine, we use four sub-doctrines, sometimes also referred to as principles in your textbook. But they are also doctrines in the sense that they have been developed through the court system. And these four are the ones you see here on the slide. And the first, they're all given to you in Latin really, but don't let that stop you from understanding really why we use them. So the first one says simply stare decisis, and it means to stand by that which has been decided. So the court stands by the decision of something similar from a previous case. Then there's something called res judicata, which means it's a thing adjudicated. And the third doctrine or principle is called ratio decidendi, which is the reason for the decision. And the last one is what's known as obiter dictum, or the plural of obiter dicta, which means a saying by the judge in a court or in a judgment, by the way. So it doesn't really affect the judgment itself, but he or she was simply saying something as an addendum that doesn't affect their judgment in that case, but could be then used by lawyers later on to build their arguments on for something similar in later cases. The key point is that if you go and read any or almost any law report of any judgment, or if you go and read the judgment itself, you are almost always not going to find any of these doctrines referred to explicitly in the judgment or the report. So don't go trying to figure out where does it say in the judgment there was a stare decisis, or what was the res judicata, or what was the ratio, and so on. This is then part of the skills, the legal skills that the jurists or the academics bring to the development of the legal system. in the sense that they are the ones, of course plus the practitioners, they are the ones that read these cases and read these reports and articulate or formulate what was the stare decisis or the ratio or the res judicata and so on. Another key point is the following diagram, which is not in your textbook, but hopefully it will help you to understand better what we mean by those four sub-doctrines of the doctrine of precedent. The starting point is outside the gray box that you see here, which is here. We're going to start with the doctrine known as res judicata. Okay. Now, res judicata means that this is the actual decision in the case at hand based on the actual facts of that case. Okay? So, for example, if you're talking about Mabu, number 2, then we are talking about the actual facts of that case in relation to the people there, in relation to the plaintiffs, in relation to their land, and in relation to their connection to that land. So the res judicata does not have any abstraction of the facts. It talks specifically about what we looked at or argued in a given case. That res judicata is not really part of the reasoning by analogy or the doctrine of precedent. It's still outside what we do in order for us to use precedent, but of course it's the basis and the starting point. So without it, without a res judicata, you cannot start formulating an analogy. Once you have the res judicata, you can then proceed to abstract from these facts. Okay. So what does that mean? So, for example, let's say that there's a case where someone bought a friend a ginger beer, and it turns out there was a decomposing snail inside this ginger beer, but because of the bottle it was in, and it was opaque, so you couldn't really see what was inside, and the person that consumed the ginger beer ended up having some physical injury or harm, and because of that they went to court asking for compensation. Now what I've just told you here is the res judicata facts. I'm talking about the specific facts that happened in the case, which is of course based on something we will talk about in much more detail when we look at negligence, which is the case of Donoghue and Stevenson. But the point is that I've just recited what the facts are in that case. That is not abstraction. However, for me to abstract, I can say that the judgment in that case, what the court decided, would apply to anything where there is a consumer, not necessarily drinking something, but even maybe applying it on their skin, for example, and where there is a container that's opaque. So it could be something inside a tube, a cream tube, that you can probably just apply on your skin, and you don't know actually what was inside the tube. Okay, because it's opaque, you cannot really look inside it. Maybe you could say that you have applied it on your skin, and once you apply it, you can see what was inside the tube, but maybe it's even then too late for you to actually see what was going on, or you might be distracted at the time by something that was happening, and you didn't actually see what came out. The key point is that now I don't really need to be too specific about the fact that it was a ginger beer. It could be a cream. Or I don't have to be specific about having a glass bottle, for example. It could be a tube. Or I don't have to be specific about drinking. It could be consumed in a different way. So now I'm trying to abstract from the actual facts in that case, namely Donoghue and Stevenson, to try and do what? To try and formulate, to try and articulate a legal principle. So something like, whenever a consumer consumes something that they cannot identify its content, or is something that's served or provided in an opaque container, and they suffer harm because of that consumption of this product, and then that would mean that there is a duty of care on the, or they would be basically able to pursue a cause of action in negligence for the recovery of damages or for monetary compensation for the harm that they have suffered. Something to that effect. I've now formulated a legal principle. And why is it again a principle, not a rule? Because it applies to so many different categories, to so many different areas under the law. Now, having a legal principle in itself does not give us a precedent. And you can see on this slide that there are two things that could happen. This legal principle could then become a ratio, namely a ratio decedent die, i.e. the reasoning behind the decision in a given case. Okay? And this brings in the other doctrine we've just spoken about, which is stare decisis. Okay? Stare decisis basically is saying that the court in a hierarchy basically stands by the decision that was made in the previous case. So if I'm arguing a case in relation to negligence, and let's assume that I'm arguing the case where the decision in Donoghue and Stevenson is still binding, let's just assume that. That means that the case was decided in a court, in the same hierarchy of courts where I am actually arguing my case, and usually it will be a higher court. Then that means I can come to the judge in this current case I'm arguing and say, Your Honor, this is what the higher court in this hierarchy decided in similar circumstances, and that was the ratio that they came up with based on this legal principle. And then the judge would say, yes, we would stand as a legal system, as a court system, we would stand by the decision we made in Donoghue and Stevenson. And the only thing, of course, now to look at is whether the facts that we have are similar enough for us to follow that decision or not. So once you can establish that that's the ratio, and once you establish that you are arguing this case in the same hierarchy, in the same court hierarchy, then you have found yourself a precedent. And that kind of precedent is said to be a binding precedent. That's the left-hand red path that takes you from the legal principle to the precedent. On the right-hand side, the blue path takes you from the legal principle to a precedent, but this type of precedent is non-binding. So you can still cite it as a form of persuasion to persuade the judge to adopt your point of view or your argument, but they are not bound by that argument or by that precedent. And the reason for that is that the decision you're looking at, so for example Donoghue and Stevenson, was talking about an obiter rather than a ratio. So if you find a statement by the judge in Donoghue and Stevenson that talks about facts different from the facts in that case, for example, there might be a statement by the judge saying that however, had the ginger bottle beer been bought by the plaintiff herself, then there would be, for example, a remedy in contracts. That's not the case in Donoghue and Stevenson, because the plaintiff there, Donoghue, obtained this ginger bottle through her friend as a gift. She was just giving her this. She bought basically this ginger beer for her. Her friend bought this ginger beer for her, and that makes it difficult for you to argue anything under contract law. But if there were, and I'm not saying there were, but if there were a a statement by the judge in that case that, in fact, if this was the case and the defendant bought the ginger butter beer herself, then she could, of course, also look at the possibility of having a remedy under contract law. That would be obiter, because the judge was talking about something hypothetical. It did not happen. But it's still useful, because those other facts that are different from Donohue-Stevenson could in fact be facts that you could find later on in a different case, and then you can use the statement from Donohue-Stevenson as in support of your arguments in this later case. But remember that would always be an unbinding precedent. Alright, I'll leave that to you to digest a little bit, because I know that all of this is new to many or most of you. So just take it slowly again and look at what you have on page 90 in relation to the discussion of these four doctrines that together create this doctrine of precedent. And you'll find some examples given to you, for example, in relation to obiter. A good example is given to you from Hedley-Byrne from the UK, from a case from 1964. Go through, please, the readings there and make sure that you understand the difference between a ratio and an obiter, and why you need always a ratio in order for you to establish a binding precedent. You need the ratio, the stare decisis, but also you also need to make sure that you are arguing the case in the same hierarchy. Otherwise, it would not be binding either. Alright, so this is just a rehash, a summary of what we just said. If it's a ratio from the same hierarchy, it would be binding on lower courts in that hierarchy. If it's an obiter, it's non-binding. If it's also a ratio but in a different hierarchy, so for example, Donohue-Stevenson was decided in the United Kingdom. If I now go and try to argue it anywhere in Australia, it's going to be at best an unbinding precedent, because again there's now a complete separation between the legal systems in Australia and the UK, and which means that at best whatever you cite from the United Kingdom, not just Donohue-Stevenson but any other case, would only have a persuasive weight rather than a binding precedent. Okay. Now there's some discussion of advantages and disadvantages of this doctrine of precedent, and you can find them listed for you on page 94. Advantages, for example, include things like promotes consistency, which is one of the characteristics that we wanted to have in our legal system, if you recall, and I believe that was in the earlier chapters that we've looked at, and I believe that was in chapter 1 under page 6, on page 6. So you'll find things like characteristics of a legal system. So the idea that this serves this purpose of promoting consistency, coherence, certainty, efficiency, and justice. But there are also disadvantages, so it may not be relevant to today's circumstances. So if you bring me a precedent from the 18th century or the early 19th century, that might not necessarily have the relevance to what we are doing today. But of course, I cannot, as a judge, I cannot just simply say, oh, because it's from the 18th century or the 19th century or the 20th century, I will not actually follow this precedent. If it's a precedent and a binding one, so if it's a part of the stare decisis argument and it is from the same hierarchy, so you have provided this ratio that's actually binding on me, then I cannot just simply say I'm not going to follow it. So that's one of the disadvantages that we have of, from this doctrine of precedent. I shouldn't follow it, but I can't and I don't have the authority not to do so. And we could probably talk about Milirrpum, if you remember, and what we said there, and the fact that that court in the Northern Territory and the judge there was not able actually to declare Australia as not a terra nullius. And the reason for that was simply because he was bound at the time by a case the case of Cooper and Stewart from the United Kingdom, from the appellate cases, and that's the thing that we're talking about here, that was difficult for them to move away from that precedent, which is a disadvantage, and we had to wait until 1992 until Mabou and the High Court of Australia, which by then of course had its own jurisdiction and was the final arbiter, and by then we had a complete separation between these systems, legal systems in Australia and the United Kingdom, to the point that we don't have to follow their precedents, and that gave Mabou the ability to declare Australia finally as not a terra nullius. Another disadvantage is slow to respond to community changes and may require an act of parliament to change. Okay, we talked about what a binding precedent is, okay, and we said that a court is part of the same hierarchy if it is linked by a right of appeal. So this was from previous discussions on the court system in Australia and the idea of the hierarchy within the court system, and the idea that it is always the ability to appeal from one court to another that makes that gives you this hierarchy, and hence the ability to use that precedent in that hierarchy. And the idea that the position of the court of record in the court hierarchy will determine if the ratio is binding or persuasive. So if the court is higher than the one you are arguing your case in, so for example you are in the district court and you're arguing from a case that was decided by the High Court of Australia, then that means that what you're talking about is in fact a binding ratio or a binding precedent. However, if it's the other way around, if you are actually litigating in the High Court of Australia and you bring up a case from the district court, then of course the ratio from the district court itself wouldn't be binding on the High Court of Australia because it comes from a lower court. Okay, I've talked a little bit about what a persuasive precedent is. So it can only influence a decision. And we said that examples of such precedents are the obiter dicta statements. So these are the obiter from a court of binding status within the same hierarchy, or another example, decisions of equivalent or higher standing courts from other hierarchies, so from other countries, for example, cited in argument in a local case being heard. For more details, you can also look at the examples given on page 95. All right. There are, of course, rules for the doctrine of precedent, and the diagram I've shown you earlier really summarizes these rules. In a nutshell, the decisions of higher courts are binding on all lower courts in the same hierarchy, and that the decisions of lower courts are not binding on the higher courts in the same hierarchy. That courts are not bound by decisions of courts in other hierarchies, and that judges at the same level do not have to follow the decisions of other judges at the same level. But in the interests of consistency, they usually do. So for example, if you have a case from the High Court of Australia and you want to cite that case in a current case that you have with the High Court of Australia, more likely than not the judges will follow the High Court of Australia decision in the previous case. Okay, and that so the last one that you need to remember is the High Court itself, the High Court of Australia, does not feel bound to follow its own previous decisions, even though they will have this idea that they will follow the decisions of other judges at the same level, because the High Court of Australia is the highest and final appellate court in the land. They will have to be able to have this flexibility of not feeling bound to follow their own previous decisions. But again, 4 and 5 together mean that they are going to look favorably at these previous decisions. But if in fact it is something that they have to diverge from, that they have to develop the law in a different direction, then that's what their job is, and that's what they are going to do. So they are going to actually move away or overrule a previous judgment in order for them to develop the law in certain directions. So the open options when it comes to a precedent, when you cite a precedent in the court, what could happen? So you bring up a case from the High Court of Australia and you argue based on that case. What could the judge or the court do? Well, they could adopt it, so they will follow it or apply it to the existing proceedings, or they could affirm it. So for example, the High Court of Australia could affirm an earlier decision, so they would agree with it, or it could be reversed or overruled. What's the difference? When you say it's reversed, the decision is changed by the appeal in a higher court being upheld. So what we are talking about here is talking about the same case going through the legal system. Okay, so the previous decision on the same case is reversed. So if you were, for example, in a federal court and then you appeal to the High Court of Australia, the High Court of Australia could reverse the previous decision because it is the same case. If it's not the same case, it's a later case that you're talking about, and you cite a previous decision, we say it's overruled. So an appellate court decides a similar matter in a later case on the basis of a different legal principle. So in this event, the ratio decidendi of the latter case decided in the higher court is followed, and the earlier decision is no longer considered to be good law. So again, the overruling happens with later cases. Okay. In a later case, an appellate court decides a similar matter on the basis of a different legal principle. In this event, the ratio of the later case decided in the high court is followed, and the earlier decision is no longer considered to be good law. The case could also be distinguished, so you will find some material difference between the facts to the point that says that you don't need to, or you'd be able to distinguish this precedent so it doesn't have to be followed. Okay, allowing it to qualify or avoid, the court then qualifies or avoids an earlier precedent without the need to overrule it, because simply the facts are too different, or the material differences between the facts. Or the court could disapprove of a precedent. So if the court cannot overrule a case, okay, it may state by way of obiter that the earlier case is no longer good law. That the earlier case is no longer good law. Alright. So let's then move on to our third learning objective, which requires us to define the key points about statute law and describe how it's made in Parliament and by subordinate bodies. Now, the key point I suppose here is to understand how statute law is made. Okay, the discussion starts on page 97, and there are some key important points in the brief box for you to look at. Okay, and another point probably that's very important to look at also in this brief box is the penultimate bullet point, which talks about that statute law can be made retrospective, i.e. to apply to transactions before the legislation was enacted, although this is a relatively rare event because it can lead to uncertainty, as people will not be sure whether what they did today will still be legal tomorrow. So one example of this retrospective legislation is what we heard recently in relation to the overhaul of the citizenship law in Australia, and the idea that it started to have effect even before any acts are passed in the in Parliament, and that they will, for example, have effect I think from the 20th of April or something like that, and the idea that everything that happens after that date, even though we still don't have a law, will be backdated to the 20th of April. Some people might argue that this has also ramifications in relation to human rights, rather than just the favorable characteristics of a legal system, but it's always a balancing act. And the reason why they wanted to do it retrospectively is in order for them to prevent any floodgates or basically an avalanche of applications, fearing that if they don't apply early enough, that they would be caught by these new laws. All right, let's then talk about something else for now. Let's talk about double dissolution. Let's first talk about the process through which the statute is made. And there's a good summary chart, flow chart on page 99, figure 4.3, and takes you through the various steps through which you can see on this slide, through which the idea behind the statute has to go before it becomes the law of the land. So again, for example, the citizenship laws that we are now looking at overhauling, and the changes or amendments that will come through Parliament on those laws will have to go through this then process. So they will have to be introduced by the Minister for Immigration, and then you'll see that it has to go to the Legislative Committee of Cabinet and the Office of Parliamentary Counsel, and then it starts its journey over three types or three stages of reading. The first reading is simply a formal introduction. The second reading is where there's a minister's speech for the reasons for the bill, and there might be a reference to one or more of the committees of the of Parliament for them to have a look at the bill in more detail, so clause by clause, and finally it comes to a third reading where you have the debate and the voting. Once it's passed, it goes to the Senate. So this is just the House of Representatives, goes to the Senate, and it's processed again another time, similar to that we have in the House of Representatives. And once it's passed by the Senate, it's enacted, and there would be a royal assent by the Governor General, and finally it would be gazetted or published in the Commonwealth Gazette. Alright, now there's a point that I want to just talk about briefly, which is the idea of double dissolutions. That starts on page 101 of your textbook. So on page 101, it simply says, it gives you an example of what would happen that leads to double dissolution. If there's disagreement between the two houses at the federal level, so the House of Representatives and the Senate, standing orders, so these are the rules, the procedural rules for Parliament, provide for conferences at which the houses, each represented by a small number of members known as managers, resolve these disagreements. And these managers of the two houses then meet to try to agree on the changes that should be made on the bill. So they give you an example. If, for example, the Senate twice rejects or fails to pass a bill, or passes it with amendments to which the House of Representatives won't agree, and if there is an interval of 3 months between rejections, the Governor General may dissolve both houses simultaneously and call for elections to the House of Representatives and the Senate. That's why they call it double dissolution. Okay, it has taken place 3 times at the federal level in 1914, 1915, and 1974, but a joint sitting followed only in 1974. And the idea of a joint sitting is that if the deadlock continues after the election, the Governor General may call a joint sitting of members of both houses, who then vote together on the proposed law. Alright. Our last objective for Chapter 4 asks us to identify the rules of statutory interpretation and explain the purpose of delegated legislation. Now, there are maxims, what they call maxims of statutory interpretation, and you'll find that they talk about these as common law rules of statutory interpretation on page 103. And these include the ones listed as well on this chart or on this slide. So if you go to the right hand side under common law rules and then you go to the left hand side under common law rules for statute interpretation, you'll find examples of literal approach, golden approach, and the mischief approach. Okay. And on the right hand side there are also what's known as maxims, and we'll talk about these in just a minute. And these are the ones that decide how you can formulate precedents, how you can connect the ratios from one case to another. Now there are also statutory rules under acts. So the Parliament has passed acts, interpretation acts, and these are really the most important interpretation tool today, and they're supported really by the other common law rules. And these acts, interpretation acts, are highly or heavily weighted towards the purposive approach. Okay, and there's also some reference to extrinsic materials, so things like Hansards that we talked about earlier, or other things that are related to the readings or the discussions in relation to the bill before it was passed and so on. These also become useful or available tools for you to use in interpreting any statute or act. Okay, so in a nutshell, if we want to talk about what these approaches are, there's the literal approach, which really says that the courts assume that the meaning and intention of the legislature is clear in the statute to be interpreted, and that the courts need to do no more than give effect to the words found in the statute. That was really the first approach that we had in relation to interpreting acts of parliaments. Later on, things evolved into a more sophisticated approach called the golden approach, which simply says that you start basically from the plain meaning approach. So you start with the words, but you adhere to that meaning only if you don't see any problems with it. Okay? So if the plain meaning leads to things like absurdity or injustice or repugnancy, then you have to adjust your approach so that you have to go on and look at the purpose behind the act. Okay, so if there are issues in relation to an absurd interpretation that comes out if you look at the meaning of the words, or repugnancy with other laws, for example, based on that interpretation, you have to move and go beyond just the literal meaning and go beyond that to entertain the purpose of the act. There's an example given to us in the case of Lee and Knapp from, again, the United Kingdom, from the Queen's Bench from 1967 on page 105, and I'll leave that for you to have a look at as an example of what we mean by issues or problems with plain meaning of words. Similarly, you can also see that the literal approach sometimes is not possible because words or phrases are ambiguous, okay, or vague or uncertain. Okay, what does that mean? When we say ambiguous, there's more than one meaning, yeah. But when we say it's vague, there's no meaning because there's lack of information. Okay, so you need more information. And there's of course the uncertainty basically, because you have contradictory meanings based on the literal interpretation. And again, the mischief approach really asks you to determine the purpose of the statute, although it didn't allow the use of extrinsic material. Okay. So after all of that, we came up with the sort of more updated version of these approaches, which we refer to as the interpretation acts. For example, there are Commonwealth interpretation acts, as well as state interpretation acts, and you'll find the summary of these acts in table 4.1 on page 107, and it will tell you which sections talk about the purposive approach, or about the use of extrinsic material, or even about delegated legislation. So really the emphasis that now these acts require the courts to interpret the words in the legislation in such a way as to help the legislation achieve its purpose. Alright. The last thing I want to talk about before we end on this part is the maxims. And these are the common law rules, maxims, and we're going to focus on two of these. And the idea here is that these are available to assist the courts or decision maker in determining the meaning of a word or phrase, although the all-important matter is to consider the purpose of the statute. So these actually maxims are trying to get you, to help you to understand the meaning of the words. So the focus here is on the meaning of the words. The first maxim is known as non sequitur associii. It's also known as the context rule. Okay, so it simply says that the words of a statute will have to be interpreted or construed in light of their context. Again, what does that mean? So an example on page 108 from the case of R and Anne Harris, again from the United Kingdom from 1836, says that the words "if any person unlawfully and maliciously shall shoot at any person, or shall by drawing a trigger or in any other manner attempt to discharge any kind of loaded arms at any person, or shall unlawfully and maliciously stab, cut or wound any person with intent in any of the cases aforesaid, to maim, disfigure or disable such person, or to do some other grievous bodily harm to such person." These words were considered by the court to cover only wounding by an instrument, not by hands or teeth. Another example is the maxim of ejusdem generis, which is a subset really of the rule of the context rule or the non sequitur associii. Sometimes we refer to this ejusdem generis rule as a class rule, and simply means that the same kind, class or nature, and is known, as I said, as the class rule. And this rule is used to find a viable meaning for a broad general word such as building, when the word follows a group of more specific words. And I'll give an example in the textbook when it says any house, flat, villa, unit or other building, and is based on context. So in this example, what we want to ascertain is or other building. So the idea is, would or other building be open to certain other possibilities, for example like a caravan or maybe a boat. So this is the idea. The idea is that we would identify a class. The class in this example is a house, flat, villa or unit, and then we want to see if another word such as boat, for example, would qualify to be part of this class. Okay, so I'll leave it for you to have a look at as well in the context of interpreting the meaning of words. Alright. So we have looked at the context and the rule, the context and class rules, and there are also other things that we look at in relation to dictionaries. For example, they are given a dictionary example on page 108, the Macquarie Dictionary, and of course also word problems in relation to means versus includes and versus or. Again, I'll leave that for you to have a look at in relation to the differences of these instruments, the differences between these words and how they impact on your interpretation of statutes. Okay. Let's then move on and talk a little bit about delegated legislation. So this is the discussion you have on page 110 of your textbook. And because of the complexity that we have in society today and the specific sort of knowledge that you need in order for you to pass certain laws in relation to technical areas, for example in relation to construction, in relation to medicine, in relation to even things like education and so on, you'll find that Parliament will not have the time to deal with all of these matters. What they do instead is basically, again, because of efficiency, they will always delegate the power to make the necessary rules to subordinate authorities such as government departments, local government and statutory bodies, for example, electricity and hydroelectric authorities or gas and fuel authorities. Okay, so the most common of these rules are known as bylaws, or now they call them local laws, regulations, and orders in council. Okay, and in order for these regulations to pass as law, they generally only need the assent of an authorized minister or officer, and they don't basically require the approval of Parliament. Now, while they do not require this approval of Parliament, they must be tabled or presented before each House of Parliament. The tabling regulation requires, of course, allows basically the Parliament to disallow a regulation. Okay, regulations must be tabled, for example, in the Commonwealth Parliament within 15 sitting days of notification, and either House may disallow this regulation. A point that we also want to talk about in relation to delegated regulation is that you can challenge this delegation. Okay, so the validity of a regulation can be challenged under administrative law, under something called judicial review. And finally, you will have something in relation to advantages and disadvantages in the inbox brief on page 111. So we said it's mainly about efficiency, but also disadvantages like the idea of lack of adequate checks and balances, even though we have this power of Parliament to overrule or disallow a delegated legislation. Generally, really, there's a increasing cause of concern that we are becoming now over-regulated as a society, and our society's rights and freedoms are being eroded. And because of that, you'll find that both the Commonwealth and the states have special committees to review delegated legislation. So there are committees, for example, in the Commonwealth Parliament, it's the responsibility of the Senate Standing Committee on Regulations and Ordinances to go ahead through this review process. Okay. The task of the committees is to ensure that the delegated legislation is in accordance with the Enabling Act and not an attempt at a major change to the law. So every regulation has an enabling act that gives the power to someone other than Parliament to actually go and regulate in that manner. And these committees want to make sure that there is this link or the authority that is available in the Enabling Act is in fact a match to the regulations that were passed. All right. So I think we'll leave the discussion here, and that brings us to the end of our recording for Chapter 4. Next, we're going to start on Chapter 5, and we will talk about civil liability and the law of torts and negligence, and that will continue for a while under the larger Part 2 of your textbook, which is in relation to civil liability. Thank you for listening and watching, and we will start on Chapter 5 in the next recording.